a succession claim, and who can claim, in fact, succession when it comes to shares and debentures, according to a new ruling by Supreme Court. Only people who are either a part of the inheritance, the will, or the succession plan, or according to succession laws, can claim an inheritance after the said person is deceased. Now, this will have ramifications for, I think, everybody out there who is either devising or not devising a succession plan, or comes out with a will or does not come out with a will, because the person you have nominated essentially for your mutual funds and to all the other wealth that you accrue over a period of time, that nominee will not get it until you have a successor in place. Is that the reading of the Supreme Court?
So, Shweta, as I read it, the Supreme Court ruling has actually upheld a previous division bench of the Bombay High Court, which had also ruled similarly, specifically in the context of shares and debentures, stating that a nominee on the share certificate or the debenture certificate is in fact nothing but the caretaker of that particular asset until it is passed on to the real legal inheritor. And a nominee, even if you are named on the certificate as a nominee, it just assigns you as a caretaker to ensure that it is rightfully passed on to the legal successor. And the Supreme Court has upheld this Bombay High Court verdict, which was challenged in 2017, stating very, very clearly that the succession laws or the will of the person who has deceased will determine that the shares and debentures, these assets, will be passed on to whom. In the absence of a will, the regular succession laws are going to take precedence, and the nominee, the name of the nominee on the documents, on the certificates of shares and debentures, only entrust that particular nominee to take care of transferring those assets to the legal successor, and it does not make them the default inheritor of the wealth.
Right.
Now,
So
you're right. Right now, it is limited to shares and debentures, but I think this opens up a whole new debate on mutual funds, fixed deposits, lockers. All of these require nominees, and in fact, banks
money
have
invested in markets, perhaps.
Markets, that's what I think. So, shares and debentures have been given a sort of, the clarity has come in by way of Supreme Court. But I think all other market-linked instruments like mutual funds, your fixed deposits, bank lockers, bank accounts, and banks have become very proactive getting account holders to do the complete KYC as well as put a nominee's name on it. But this nominee may or may not be the legal inheritor of that wealth. So I think it opens up this whole debate about being a nominee is likely to be just being the caretaker of the wealth and not the owner of that wealth.
That wealth. So, if let's take a quick example. Let's say I do not leave a will behind, but I have nominated and I make active investments in the markets, and I have nominated a certain individual, let's say a friend, can't nominate a friend, but let's say my parents, and I don't leave a will behind, in which case, as per either the succession laws, because there is no will in place, either my children or my spouse will get the wealth, will get those instruments of investment, and not my parents. So either the will would stay or the succession plan.
I mean, I'm not sure about parents being rightful inheritors or not, but succession laws is what we'll have to dig deeper into. And whichever of the relationships takes precedence is going to be the legal inheritor, notwithstanding what name you've put as a nominee on your documents.
All right, so those are interesting details coming